Hasluck.
Thank you, Deputy Speaker. I rose to speak on the bill for an Act to amend Native Title Act 1993 and for related purposes. I was around at the time when discussions on native title commenced, and I remember sitting with Rob Riley, who has since passed away, and Peter Yu, Dennis Eggington and many other great leaders talking about what the Native Title Act would mean, the opportunities it would create, but the other important element was the empowerment. The empowerment in many forms, not only in terms of determining use of land, but determining opportunities to create economic empowerment, and in a way that meant that we sat as equal partners within those negotiations with all parties. And both the Mabo and WIC decisions and the Native Title Act were probably salient points in the history of this nation in which it changed the relationship between all Indigenous Australians and then all entities of Australian society, because it created a sense of understanding that registered across the whole of Australian society. Whilst many may have reacted, both in unkind responses, because I did hear a state premier who made the comment, "There goes our backyards under native title," but that was never the intent. And the Act has served Aboriginal and Torres Strait Islander communities well, up until the 2nd of February, when the full federal court handed down the McGlade versus native title decision, which then had unintended consequences that had not been thought of. And the McGlade decision created uncertainty in the native title sector regarding the status of areas of the ILUs. And that meant that area ILUs registered without the signatures of all RNTC members, including members who are deceased, were agreements which did not meet the requirement for ILUs as defined under the Act. And area ILUs lodged for registration which did not comply with McGlade could no longer be registered. And so it's obvious and natural that a government would respond by looking at the remedy to ensure that all of these agreements have the status that is expected by those Indigenous communities and areas where these agreements had been entered into. And certainly in phone calls I've received, land councils have asked that we do something to remedy the outcome of that decision and to support any legislation that requires to address the issue of uncertainty created by the High Court. And to this extent, the Attorney-General has proposed that the amendments to the Act will achieve the following. It'll secure existing agreements which have been registered on or before the 2nd of February 2017 but do not comply with McGlade. And I think that is a very relevant, salient point to give absolute certainty to all of our traditional owners and all of our communities who have native title agreements that are in train and that have been negotiated in good faith between all parties, to enable the registration of agreements which have been made and have been lodged for registration on or before the 2nd of February 2017 but do not comply with McGlade, and C, clarify who must be a party to an area ILU in the future unless the claim group determines otherwise. Those changes are important changes. They do not alter the intent of the Native Title Act, but what they do is give certainty to the agreements that have been struck in Commonwealth legislation. None of us ever foresee the decisions of high courts and the ramifications of the full federal court and what the implications are until those decisions are handed down. And whilst we might have, as been referred to, some prior knowledge of what might be an unintended consequence, we cannot act on those with the degree of certainty as implied until those decisions are made. And I would hope that in this debate that what we do is we focus on the amendments that are being suggested. What I certainly have heard is criticism of the Attorney-General, which is not the basis for the change. See, everyone is in agreement, from what I ascertain in talking with colleagues on both sides, with the amendments that are needed to remedy the implications of the recent federal court decision, and their commitment to Aboriginal and Torres Strait Islander people across this nation has not altered. And so on that basis, I would hope that we would focus on the amendments proposed and not on the peripheral matters that I hear being raised, because the certainty that is needed is not only with Aboriginal and Torres Strait Islander people, but it is with those parties who've entered into the agreements that they can plan the way forward as agreed and honour those commitments. This bill will move through this House. It'll complete its journey, and then it'll spend time in the Senate, where for the next 4 weeks consultation will be occurring through the committee process within the Senate. And I think that's an important element of this whole debate, because it'll allow others to contribute to the impact of this decision, but also for them to present their point of view on the importance of these amendments being moved through expediently through the Parliament, both this chamber and the Senate, to enable their planning and their consideration of land use to proceed in the way that had been planned. When we tackle this complex issue and take it from personal perspectives, then I think we demean the value of the amendments. And I would hope that the rest of the debates that I hear are about the way in which we collectively in this chamber support those amendments that will make a difference to the decision that arose out of the full federal court. Because when I look back on the closing the gap targets and our failure to meet them, and I look at the economic pathways and opportunities that are available to Indigenous Australians through native title land use agreements, then that is an avenue to bring together opportunities for all of us to effect the changes that will close the differences in what we have seen as the levels of disadvantage that have prevailed in this country for so long. I certainly appreciate the comments made by my colleague, the member for Barton, in terms of what land means to us, what country means, the beauty and the richness of connection to country and the relationship that is important to all Indigenous Australians. But equally, we have to also acknowledge that through the Indigenous Land Councils, when they express a view that they want government to make the amendments so that they can continue with their negotiations, then I think that is also an important step in listening to the voices that prevail, who have negotiated these agreements over a period of time and who can see the economic advantage that is important to the people that they represent. And I would ask all colleagues in this House to focus on those very particular issues. And whilst there might be views about the Attorney-General that are being expressed, that's not the primacy of this debate and the debate of this legislation. What we need to do is demonstrate that we are totally committed to the way in which the intent of native title, as negotiated in this chamber over a lengthy period of time, and Paul Keating's commitment and stance in what was being pushed for and eventually achieved, gave a great opportunity to create those economic pathways. But it wasn't only just economic pathways, it's also the importance of country. And having native title, it means that association continues and becomes very critical in the way in which our culture continues to maintain its existence with Mother Earth and the surrounds that have been important for periods of in excess of 60,000 years. And so I'd ask all members to focus on the amendments, to allow the Senate process of consultation over that 4-week period to occur, and that we collectively stand together. And I'd ask Labor to stand with us on this in terms of the amendments, because as my colleague sitting opposite me, the Shadow Minister Snowden, knows only too well that when we're out in communities, we're sitting down in the red dirt talking to people, land always is raised. The use of land has always been paramount in many of those discussions. And I know that there will be individuals and groups that will be disappointed with that full federal court decision, because what they see is the potential for an opportunity to slip away. And on that basis, Deputy Speaker, I would ask that we give credence to the process in this House, but to focus on the amendments, but to equally stand together to ensure that this bill passes through to the Senate, that the Senate is able to do its committee work, and then for the Senate to deliberate in its considerations. And I would also ask the Greens to stand with us on this issue as well, because yesterday I did, and I do know that Senator Rachel Seward has played a significant role in being a champion for many of the things that Aboriginal and Torres Strait Islander people aspire to. And I know that when she has been out within communities, her heart and her soul is enmeshed within the thinking of those discussions. And she and I have had some great conversations of many of the issues that have arisen out of people's reliance on country, their reliance on land, reliance on the opportunities. And so I'd also ask the Greens to stand with us on this one as well, to right a wrong in one sense, to make the amendments ensured through both houses, so it gives back to all Aboriginal and Torres Strait Islander people the certainty that they deserve and the certainty that they have always anticipated and expected with native title. I thank you, Deputy Speaker.
I thank the member for Hasluck. Question is, the bill be now read a second.